Stuart.
Thank you, Ronald. If we can take a look at paragraph 26 of your statement, Mr. Leader. You say there that the figure of $50,000 was settled on relatively quickly. Who proposed it?
I don't recall specifically who proposed it.
Was any budgeting or forecasting or done in order to arrive at an appropriate cap?
No, not so far as I know.
Were any actuarial calculations done?
Not so far as I know.
So am I to understand you then that no budgeting or forecasting in relation to how much might have to be paid was done?
Not so far as I know.
And nor how much it might cost to run the scheme?
Again, not so far as I know.
So are we to understand that affordability was not a consideration in arriving at a cap?
That's correct.
Could look at tab 13. Now this is, as it were, the culmination of a number of different drafts of the four-part plan, and this is the one that was ultimately announced on the 30th of October 1996. Is that right, Mr. Leader?
Yes.
What I intend doing is looking at each of the components of it, and we'll have a discussion of each of those, and we'll keep coming back to this document. So, starting then in on page 2, and at paragraph 2, one of the components is obviously the independent commissioner. In your understanding at this time of the conceptualization and adoption of this scheme, the reference to independence there is an independence in what sense?
An independence from the Archbishop and the Archdiocese.
And what were the considerations in that independence being seen as important?
Well, I think they were seen as being completely fundamental and really reflected, had been reflected in all of the discussions that I'd been involved in with Archbishop Hart since I first met him in late July 1996, that the proposition was, and is, that there ought be an investigation of allegations independent of the Church.
And I take it, by your use of the word investigation, you're including also a decision on the allegation?
Yes.
Yes. And so one sense of independence might be independent of external influence in decision-making. That was part of it, I take it.
Yes.
Another sense of independence might be structurally independent.
Yes.
Was that another component to the independence?
Yes.
And, of course, another would be the perception of independence. That would be important too. In other words, that complainants perceived and understood the independent commissioner to be independent of the Archbishop and the Archdiocese.
Yes.
Now, if we can just do a brief excursion backwards to tab 9. A few days earlier, you had done a brief comparison of the Emerging Towards Healing document and the Melbourne response document as it was at that time. Is that right?
Yes.
And this table sets out your points of comparison. Is that right?
Yes.
And in point 4, you will see under the left-hand column, which is headed National Document, which is obviously the Towards Healing document. Is that right?
Yes.
It refers to clause 3.4, which defines contact persons to receive complaints, which are then assessed by assessors. And in the right-hand column, which is the column for the Archdiocese four-part plan, it says, or it records that it's to ensure the independence of the commissioner. the initial complaint is received by his office and assessment is performed by him. You see that?
I do.
Now, I take it you shared the view that that part of the Melbourne response was preferable to the towards healing.
I did, but I see merits in both. I can absolutely understand the proposition that for people to go and see a QC is confronting. I can also understand that to have to tell your story or part of your story to a contact person and then have to tell it again to an assessor is difficult for a victim. So I can see merits in both, but ultimately my personal view was that so long as the right person was chosen as independent commissioner, that it was preferable to have a system that hopefully required the victim to only have to tell their story once.
As I understand it, in the way in which the towards healing system has played its self out, and you can tell me whether you're aware of this or not, it is sometimes the case that the contact person records the story for the assessor and that it's not then necessary for the victim to retell the story to the assessor.
I'm sure that that occurs on some occasions. Certainly back in 1996, what was anticipated was that there would be many more contested hearings than there were. And it does seem to me that if there is a contest, so if the accused priest is denying the allegations, then it would be difficult for the assessor or independent commissioner, whoever is having to decide on the validity of the complaint, to make that decision without hearing directly from the victim. I think it would be difficult to resolve that sort of contest based only on written statements.
Yes, well, that's a matter I'll come back to, but just while on this question of making the decision, at the time that the Melbourne response process was adopted, had consideration been given to the standard of proof that might be applied by the independent commissioner in making a decision?
Not so far as I can remember, no.
So would it be right that that was essentially something left to the independent commissioner?
Yes, yes.
Yes, and we've heard Mr. Callahan's evidence in relation to that.
Although, if I may, having said that, one of the things that was being considered at the time was how the independent commissioner process sat within canon law, and as best as I can remember, I did have some understanding of the standards of proof required by canon law. So I think that we were, without necessarily having a vision of the entire way through this difficult issue, it was seen as important, at least relevant, to think about how the findings of the independent commissioner would have status or relevance at canon law.
While on the subject of canon law, the independent commissioner's process was seen as fulfilling the role of a preliminary investigation under Canon 1717, is that right?
Yes.
If we can go to tab 1. And scroll down to look at Canon 1717, number 1. Whenever an ordinary, and an ordinary is a reference in this case to the Archbishop, that would be right?
That's fine. Yes, I believe so.
Has knowledge, which at least seems true, of a delict, and a delict would be, in this context, a crime.
Yes.
he is carefully to inquire personally or through another suitable person about the facts, circumstances, and imputability, unless such an inquiry seems entirely superfluous. So that's the threshold, as it were, to get a preliminary inquiry going, is that there's information or knowledge which at least seems true.
Yes.
Yes. And then there are various other provisions, and in sub 3, the person who conducts the investigation, that would be the independent commissioner, am I right?
Yes, yes.
Has the same powers and obligations as an auditor. That's a reference to a judge within the canon law system.
I don't know, but that does seem to make sense.
And then in 1718, number 1, when it seems that sufficient evidence has been collected, the ordinary is to decide, and then there are 3 options that are set out, whether a process to inflict or declare a penalty can be initiated, or whether, attentive to Canon 1314, this is expedient, or 3, whether a judicial process must be used, or unless the law forbids it, whether the matter must proceed by way of extrajudicial decree. So those are then the options that become available to the ordinary once sufficient evidence has been collected. And if we can go over to the next page. So in 1717 itself, there isn't a standard of proof particularly, as I see it. Do you have a different understanding?
I would agree with you that looking at 1717, it doesn't seem to say that. Well, it doesn't say that, but I don't know whether there are other provisions of canon law that would impose a standard of proof. I have an understanding that for certain canon law purposes, a standard called moral certainty is required, and I have been told by Mr. O'Callaghan that his understanding is that that is equivalent to beyond reasonable doubt in our system, but I'm really far from an expert on these matters.
And that would be in the event that the ordinary exercising a decision under Canon 1718 decides that there be a penal process, in other words, a canonical judicial process, then that standard would apply. But if you don't know...
I really don't know.
I've had the benefit of having to do a whole hearing on canon law, as the commissioners have had to hear about it too.
I really can't. I really don't know.
Right. And would it be right then that you don't know that canon law generally does not know an oral process? What we were told previously, even in the judicial stage, it deals with matters on the documents, including sworn statements or affidavits, and decides on that basis.
I have been told at some point by a canon law advisor that one of the practical difficulties of seeking to impose a canon law penal process to adjudicate on an allegation of sex abuse is that the victim and the offender would need to confront each other. So I did have an understanding that there would need to be an oral hearing with a panel of priests sitting as judges, and from my perspective, I could see that strikes me as a quite inappropriate way of trying to allow a victim to prove their case. So I do have an understanding that somewhere along the line there is an oral hearing, but I may be wrong about that.
Right. I'm not at all sure that that's consistent with what we learnt in a previous hearing, but we can put that aside for present purposes. That's not something that has to be resolved by any means in this hearing. You've said that from the outset it was anticipated that there would be contested hearings in the event that the accused priest denied the allegations.
Yes.
Was some other way of or process to resolve disputes such as that considered? For example, an investigative process rather than an adjudicative process?
No, I don't think so. I think that one of the things that was really absolutely fundamental was for there to be a way of dealing with allegations that either didn't go to the police or hadn't gone to the police or had gone to the police but that hadn't resulted in an outcome. And I suppose it was anticipated that there would be situations where victims made allegations and the accused priest denied them. And as best as I recall, the view was that contest was best dealt with in an oral hearing along the lines, as Mr O'Callaghan said yesterday, along the lines of a magistrates court summary hearing.
Am I to understand you to be saying that an alternative process wasn't consciously considered?
That's my memory, yes.
That as lawyers schooled in the common law tradition, it would be our first point of reference would be to have a mock trial or a mini trial.
Yes, a mini trial, yes.
So are you aware that in the towards healing process, very often these matters are dealt with by an investigator who actively investigates and then comes to a finding which the Archbishop then considers?
I am.
And do you have thoughts as to the pros and cons of those competing processes?
I do. I think one of the challenges that both systems have is, on the one hand, to deliver support and assistance to victims, but on the other hand, to remember that when a victim makes an allegation against a priest who is otherwise alive, well and in ministry, that can be career-ending for the priest, and that there therefore does need to be a process that, in cases where there's a conviction or there's an admission by the accused, this isn't a problem. But in the situation where you have someone not otherwise accused who's operating as a priest, they have the allegations against them are clearly very serious, and there needs to be the best system available for trying to determine the truth. And I suppose, as you said, with the perspective of our Australian legal system, we see that as being a hearing where there's oral evidence and the right to test evidence with cross-examination.
Another consideration, aside from the important one you've mentioned, of course, would be one of cost. That's a costly process to have a hearing of that nature presided over by a senior silk and so on. Would I be right?
It certainly comes at a cost.
But in deciding how to go ahead with the Melbourne response process, cost wasn't an issue, particularly as I understand it.
That's correct.
I'm just trying to understand the way in which such a hearing would be conducted. The independent commissioner himself, and we'll come to this in a minute, would be briefed in a formal sense by you. Am I right?
I don't brief the independent commissioner separately in relation to a contested hearing, no.
Yeah, I wasn't meaning to imply that. I mean, at the outset, he took a brief from Coors, yes, to be the independent commissioner.
That's correct.
And then when the need for an oral hearing arose, there was then another barrister appointed, typically Mr. Gleeson, as I understand it, to act as counsel assisting.
Yes.
And would there then be a separate brief to that junior, at that time, junior barrister?
I think Mr. Gleeson, I briefed Mr. Gleeson in 1997, and it was really, if you like, an ongoing brief to act as counsel assisting as required in matters as arose and as requested by the independent commissioner.
No,
that would occur without reference back to me often.
And in the presentation of the case, who would counsel assisting be taking instructions from?
I have no involvement in that.
So, and we might, I suppose, ask Mr. Gleeson about this in due course, but insofar as you know, would counsel assisting together with the independent commissioner essentially be left to independently determine what would be investigated and how the evidence would be presented and how the case would be run?
Yes.
Because you would appreciate the disadvantage in a process that left essentially the complainant to put together a case of evidence against a priest without active assistance from counsel assisting and potentially the independent commissioner who's been appointed to investigate.
I would understand that, and that's the precise purpose for having counsel assisting.
Can go back to tab 13, this time at paragraph 2.4. And firstly, in relation to the first bullet point, which deals with the terms and conditions of appointment of the independent commissioner, where it states that immediately upon a complaint of sexual abuse being made to him, the commissioner shall inform the complainant that he or she has an unfettered and continuing right to report the matter to the police. Now, these terms had been discussed with the police before they were adopted and announced, is that right?
Yes, that's right.
And this is one of the things the police had asked or said should be part of the terms and conditions.
I think that first point was in the proposal that we took to the police, and it was the second point, the encouragement of the exercise of that right, was the input from Assistant Commissioner Brown.
And then in the fourth bullet point on the screen, it says the Commissioner will respect obligations of confidentiality imposed on him by complainants to the maximum extent permitted by law, except where those obligations preclude him from doing so. He may, if he considers it appropriate, report matters to the police. Now, questions or obligations of confidentiality were then also set out in the independent commissioner's terms of appointment, is that right?
Yes, that's right.
So if we go to tab 36, you'll see that's the appointment of the independent commissioner and his terms, which changed slightly on subsequent occasions, but dealing with them as they were originally. And then particularly if on page 4, we have a look at paragraph X at the foot of the page. The Commissioner shall treat as confidential and privileged all information acquired by him in the course of his investigation, provided that subject to subclause 111, the Commissioner may, if he considers it appropriate so to do, provide the whole or part of such information to the police and with the consent of the complainant to the compensation panel. And then if we look at the next paragraph, paragraph 11, and it states, if a complainant, prior to stating the facts and circumstances constituting his or her complaint, informs the Commissioner that he or she is only prepared to divulge those facts and circumstances to the Commissioner upon his assurances that he will not, comma seems to be in the wrong place, unless required by law, disclose those facts and circumstances to any person other than a person nominated by the complainant, the Commissioner, unless required by law so to do, shall not disclose those facts and circumstances to any other person, save to members of his staff, from whom he shall have procured an undertaking of confidentiality. Now, from this we to understand, of course, that confidentiality was given a high premium in the establishment of the scheme.
Yes, to the extent that it's requested by the complainant, yes.
And as you understand paragraph 10, perhaps we can just scroll up again to the beginning. The Commissioner shall treat as confidential and privileged all information acquired by him in the course of his investigation. In preparing and being part of the process of preparing and adopting this scheme, how did you understand that? Confidential to whom?
I think the context is that he was appointed to investigate and to report to the Archbishop and the compensation panel as appropriate, and to interact with CareLink as appropriate. So I understand the confidentiality as permitting him to report to the Archbishop and the Archbishop's agents and so on, permitting him to report to the compensation panel where that consent was given as part of the application for compensation, and permitting him to deal with CareLink, but otherwise to treat the information as confidential, so that if, for instance, someone else sought information from him, he could only provide that information if he was subpoenaed or ordered to do so.
Well, let's break that down a bit. Clearly, it includes confidentiality. Within confidentiality would be the Commissioner himself and his immediate staff, and presumably also any counsel assisting appointed from time to time. That would be uncontroversial.
Yes.
Then the compensation panel, of course, is excluded. In other words, the compensation panel is a body to whom the information must not be given unless consent has been given.
That's right.
Although CareLink is not mentioned specifically in this clause, the practice was to get us to acquire a specific release to give the report to CareLink too, am I right?
Yes, that's right.
It's not immediately obvious to me why the Archbishop and his agents, by which I take you to be principally referring to yourself, why they should be included. In other words, that the Commissioner would be open to giving information to them.
I'm including also the Vicar General when I think of agents, but there would be inconsistent with the appointment of the Independent Commissioner for him to investigate a complaint, conclude that a priest was guilty, and then not be able to tell the Archbishop about it. The whole point of his appointment in that regard was so that he can report to the Archbishop and recommend action.
Well, the distinction may be drawn, I suppose, between the findings of the Independent Commissioner and more generally the information that he acquired.
I agree. And I think I'm speaking particularly of the findings and recommendations, and I don't think it's necessarily easy to draw an obvious demarcation always, because as part of the findings are more than guilty or not guilty. The findings must necessarily include some account of the circumstances, so when it happened, where it happened, and so on.
Well, there's another place where this may be further illustrated, and that's at tab 18 in your memorandum to Council in the original appointment of Mr. Callaghan on the 11th of November 1996. And when you scroll down that, you familiarise yourself with it. But in particular, the third paragraph that commences with this memorandum and the attached back sheet, we confirm that your appointment as Commissioner is made by us on the Archbishop's behalf, and that your relationship with the Archbishop is one of barrister and client. I will get to paragraph 4 in a minute, but as far as we've got, that would, of course, in the ordinary course, involve any knowledge gained by the barrister is to be freely given to the client.
Yes, I agree.
And then in paragraph 4, that's then qualified, and we can have a look at that. Because of the sensitive nature of some of the information that you will receive in your capacity as Commissioner and the need for confidentiality to protect complainants, our client recognizes that you may wish to keep information and documents that you receive or create confidential to yourself and such other persons as you select. Accordingly, you are briefed on the express basis that all information and documents that you receive or create in your capacity as Independent Commissioner are your property and will remain your property at the conclusion of your retainer. our client waives any rights that he may otherwise have to such property. So that perhaps starting to draw the line between findings and other information. Would you see it in that way?
And it's also reversing the ordinary lawyer-client information flow.
And the great relief of a barrister to send everything back at the end of a case, whereas here Mr. Callahan's being told to keep it and it's his property.
Yes.
And then in the fifth paragraph, and scroll down a bit more, however, it may be that for us to fulfill our role as instructing solicitors, there will be matters that you wish to disclose to us. We agree to receive such information in confidence and will be happy to provide formal confidentiality undertakings at your request. Now, firstly, in relation to that, were you envisaging that at the Independent Commissioner's request, you, the solicitors, would keep whatever he's given to you confidential even from your client?
Yes. Yes.
And that, of course, does happen in other contexts of litigation.
Yes.
Yeah. Did it ever happen in your experience through the years of the Melbourne response where such a circumstance arose, where the Independent Commissioner made information available to you, but only on your assurance to keep it confidential to yourself?
Yes.
It did arise. Can you give us a sense of the circumstances in which that arose?
Yes, most recently it has arisen in relation to this Royal Commission and in relation to the parliamentary inquiry. But my firm has been provided with information, and in particular the information that permits the compilation of the statistics to which Mr. O'Callaghan has referred. And there are confidentiality undertakings that I and other lawyers from Coors have given, which clarify that we hold that information for Mr. O'Callaghan and not for the Archdiocese.
So when Mr. O'Callaghan gave evidence that his files have now all been put on ringtail and they're available for access at Coors, it would be under that arrangement, would it?
Yes, expressly under that arrangement.
If we can revert to canon law briefly and back to tab 1, on the second page, canon 1719, you'll see it says that the acts of the investigation, the decrees of the ordinary which initiated and concluded the investigation, and everything which preceded the investigation are to be kept in the secret archive of the Curia if they are not necessary for the penal process. Now, would you agree what this envisages is that an ordinary, an archbishop in this case, would have an archive to keep these classes of documents?
That's what the words appear to mean.
And the acts of the investigation are the documents created or presented and provided during the course of the investigation?
I don't know. I don't know what acts means.
Was there any consideration to your knowledge of how to reconcile this requirement of canon law and the idea that the files created by the Independent Commissioner in his investigation would remain his property and confidential, at least to some extent, to him, separate from the Archbishop?
As best as I recall, we really didn't consider Canon 1719, and as best as I recall, it's possible that I have seen it at some previous time, but I really only became aware of its provisions yesterday when Mr. O'Callaghan was being asked about this.
Well, perhaps you won't be able to assist us on this, and you say so if that's the case, but you'll infer from what it's said there in Canon 1719 that any particular investigation under 1717 requires a decree of the ordinary to initiate the investigation and another one to conclude the investigation. Are you aware of that?
I can see that, but I don't know whether that is the preliminary investigation that we would suggest the Independent Commissioner is undertaking, or whether it's a process that follows after that preliminary investigation. I just don't know. But what I can say is that whatever process is contemplated by Canon 1719, it's not impacted on the operations of the Independent Commissioner or his interactions with me or the Archdiocese, so far as I know.
And certainly in the work that Mr. O'Callaghan undertook as Independent Commissioner, there weren't separate decrees of the ordinary to initiate an investigation in respect of each separate complaint as it came in.
Correct, there were not.
Or to conclude an investigation.
That's correct.
So going back, Mr. Leader, a moment to what you were saying about the ambit of the confidentiality assurance, and that certain matters certainly would be able to be reported to the Archbishop and his agents. Am I to understand you to say that that would be without a particular release from the victim who had imparted the information?
Yes.
Unless there had been a specific request as envisaged by that subparagraph, small Roman 11 we looked at earlier.
I think that's right. Yes.
Do you appreciate that there may be a difference in how you and those operating the Melbourne response conceived of or understood the confidentiality, and how victims participating might have seen it? In other words, that they might have seen it as being confidential to the Commissioner, to the Independent Commissioner, the public face of the scheme.
I'm sure that's possible, but I think it's inconsistent with the literature and the Independent Commissioner's descriptions of his functions and the sorts of descriptions that he gives as to his role. My belief is that when people come forward to the Independent Commissioner, they're coming forward to have their complaint investigated and ruled upon, and for steps to be taken in relation to the priest if that's appropriate, and that it would be, if I may say, self-evident that steps could not be taken in relation to the priest without there being a report of the findings to the Archbishop.
Well, it is the case, though, as I understand you've accepted, that certain information would be kept by the Independent Commissioner and not disclosed even to the Vicar General or the Archbishop.
Yes.
But necessarily certain information, such as the finding and what it's on exactly, would be imparted to the Vicar General and the Archbishop.
Yes.
And the line between those two is not a line which has been clearly drawn in these documents.
Not in these documents. I would see that as a matter for the Independent Commissioner to report on his findings in the way that he considered appropriate.
Well, you will appreciate, I think, the difficulty with that might be that one way of reporting would be a very full report, including annexing various medical reports, transcripts of interviews and so on. And another way of reporting might be a much briefer way, which just reports the essential facts that were found.
Yes. And if the latter is typical, except in the case of contested hearings, where more detailed reasons are provided, as I understand.
Well, possibly also in the case of Emma Foster.
Yes.
Well, perhaps we'll come back to that aspect, but Moving on now to the next component of the scheme, we can go back to tab 13. And the next component, of course, at paragraph 3 on page 4, is the professional support services. And that's what became CareLink, am I right?
That's right.
Can you explain for the Royal Commission, Mr. Leader, what the thinking was behind having the treatment, counselling and support aspect separate from the compensation aspect?
I'm not sure that I understand your question. In terms of, do you mean that one is ongoing and one is not? Is that?
Well, let me rephrase it. One way of dealing with the matter would just be to have compensation, and that deals with everything.
Yes.
Another way of dealing with it might be that the same person or group of people deal with questions of monetary compensation as well as how much other support should be funded by the Archdiocese. But a different model is one which was ultimately adopted. What is the thinking behind the adoption of this particular model?
Well, I think that the expertise that one would rely on in order to either provide counselling or treatment or make decisions about what sort of counselling and treatment is appropriate is ultimately not the same sort of expertise that one would rely on to try and assess compensation.
And it's as simple as that, different expertise?
I think it's different expertise, yes. I think it's also the case that there are some victims who seek support for counselling and treatment but don't seek compensation. And it's further the case, as we've heard, that victims will be assisted by, can be assisted by counselling and treatment through the process as well as at the end of the process, and indeed can be assisted by counselling and treatment if they're not otherwise going through the process. So, for instance, could receive counselling and do receive counselling and treatment administered by CareLink while a criminal prosecution is underway, or indeed while they're undertaking or contemplating civil proceedings.
Leader, it's a return to part of the discussion we had before lunch, but you constantly use the word compensation when speaking of the money aspect of it all. What do you understand to be the nature of the compensation? What are you compensating for?
I think it is a recognition in monetary terms of the wrong done and the harm caused, but it is not general damages or special damages in the way that one would receive, that a plaintiff would receive in legal proceedings.
So it's compensation which is for the purpose of recognition,
yes,
but not response.
Well, I don't mean to disagree with Your Honour, but I would see the recognition.
Disagree if you feel.
I would see the recognition as part of the response.
Well, it all goes back to how do you work out between 0 and 50 or 75 as now is what's appropriate. If it's compensation, well, I'm not sure the compensation is the right word, as I understand what you understand to be seeking to achieve.
That may be so. I mean, we use the phrase ex gratia compensation, which I think seeks to distinguish, and perhaps we could have come up with a better phrase, but it seeks to make the point that this is not common law damages.
Ex gratia adds nothing to the concept of compensation. It's the use of the word compensation that is interesting.
Yes.
I mean, many would say that a redress scheme doesn't provide compensation, but you've been thinking of it as compensation.
I understand Your Honour's point, and perhaps it's not the right word. I mean, perhaps recognition or redress. I mean, perhaps the word redress is more appropriate. And again, perhaps redress isn't an appropriate word.
I think somewhere it may be referred to as ex gratia payment,
Yes.
which perhaps is the least misleading description.
Yes.
It's just a payment and it's ex gratia.
Yes.
Now, you may or may not be aware, Mr. Leader, that at least in some instances in the administration of Towards Healing, an approach has been taken to limit counselling or other support, professional support, to 10 sessions, subject to review and perhaps exceptional circumstances. Was it always envisaged, in other words, from the outset of the conceptualization of this model, that the professional support under what became CareLink might be open-ended?
It was. I think the one thing that we see in this document that did not unfold as we expected was that this document suggests that CareLink would provide or could provide treatment itself. And I see their professional support services will be available directly from these staff. And that, in the event, is not how things unfolded. And that was because we realised very quickly that for many, if not most victims, the thought of getting counselling or treatment from the church, if I can put it that way, was seen as inappropriate. While CareLink was set up to be independent, the experience almost from the beginning was that the better approach was to administer the provision of counselling and treatment by third parties. I think the other thing that became apparent very quickly was that some victims who came forward already had were already receiving treatment or counselling, and that it seemed quite unwise to try and disrupt those existing relationships if they were working.
We can look at paragraph 3.6 on the next page. It raises the question once again of confidentiality. It says the service, that's CareLink, will respect the confidentiality of complainants, but will comply with legal reporting requirements. It may also disclose information with the consent of the claimant. And once again, perhaps you can give at least your understanding of confidential to whom, who's within that circle of confidence.
I think within that circle of confidence is CareLink and third-party providers retained by CareLink, although I think that there are express confidentiality arrangements signed up to. And I think absent consent from the complainant, I think that's, I stand to be corrected, but I think that's the circle.
The practice was it to get the complainant's consent before reports from CareLink or in the possession of CareLink were passed on to the compensation panel?
Yes.
And what about passing information by CareLink to you as solicitor for the Archdiocese?
There's no consent process for that to occur, and it doesn't occur.
So you would regard this promise of confidentiality in paragraph 3.6 to stop that? In other words, CareLink wouldn't pass confidential information to you unless there'd been consent or release.
I think that's right. I mean, there would be. I think the other exception to that is if CareLink or the staff of CareLink were seeking professional advice or legal advice about a particular issue, then I can envisage in that circumstance that they might provide some information. But over the years, the exchanges that I have with CareLink are almost invariably on an anonymous basis, so that I don't know who if they do seek some advice from me or seek my opinion, I don't know who the complainant is, unless it's a circumstance where I already know who the complainant is.
But you can see even in the example you've given the potential difficulty that may arise where you are the Archbishop's and Archdiocese's solicitor.
Yes.
CareLink has been set up on an explicit basis independently with a promise of confidentiality. If CareLink is then to share confidential information with you to seek legal advice as to how they should deal with a particular issue, that might be seen as a breach of this promise of confidentiality.
I can see that issue. I would say that what I'm speaking of is very much the exception and not the norm, but I can see the issue, yes.
And you'll appreciate that I'm exploring these matters because of their complexity, and they are matters that will have to be addressed in any future redress scheme if one is ultimately proposed.
I'd also, although I don't think, unlike the situation with the Independent Commissioner, I don't think it's been made express, but I would understand that I have a professional obligation of confidentiality to CareLink, and I would very clearly understand that I was not to disclose that information to the Archdiocese.
Which puts you in a difficult position in the event that you're giving advice to the Archdiocese on any issue where you've got independent knowledge from CareLink which you can't share with the Archdiocese.
It could. It could. I can't think of a circumstance where it's happened.
You may be aware one of your Sydney partners has recently published in the Australian Law Journal on questions of Chinese walls and confidentiality within big law firms.
I'm aware of the issue. I'm not aware of the article.
The next part of the four-part plan is that covered in paragraph 4, the compensation panel, just a bit further down the page.
Yes.
And the opening subparagraph 4.1 uses the phraseology ex gratia compensation. I think we probably discussed those words sufficiently. In paragraph 4.2, it says that the function of the panel is to provide complainants with an alternative to the pursuit of legal proceedings against the Archbishop or the Archdiocese. Am I right that right from inception, this compensation scheme was seen as an alternative to civil litigation?
Yes.
In other words, it wasn't ever envisaged that one might get compensation under the Melbourne response and also be able to litigate.
That's correct.
Can I ask you about that? The real question is why? Did you consider providing that the Melbourne response may provide a sum of money on condition that it be set off against any common law claim? Why was it thought appropriate for someone who might have a good common law claim to deny them the Melbourne response if they were to pursue a common law claim, or vice versa?
I don't think that we did consider that. As best as I recall, we did not consider it. What we contemplated was that victims could go through the compensation panel process, see what the outcome was without otherwise compromising their rights. And if they didn't want to accept the offer, they could then continue with or pursue legal proceedings. But I don't think that we contemplated the option of both.
You see how by saying to someone, you may get $50,000, but you can't sue us, but you get $50,000 now, would operate as a serious disincentive to someone who might in fact have a good claim because of the difficulties of the common law process.
Yes, I can see that.
Do you think on reflection that it should have been framed so that if you accepted a modest sum under Melbourne response, you were denied any opportunity for a common law claim?
Your Honour, I can see arguments both ways. I'm aware, for instance, that the Defence Force scheme does allow applicants to receive a payment from that scheme without giving away their legal rights.
What's the argument in favour of requiring them to forgo all their legal rights in return for a modest sum?
Your Honour, I think there are a number. One is obviously finality, which might be seen to be advantageous to one party or to both.
That's finality for the church, but
yes, and finality for the victim.
How is that a benefit if they've just got the option? They can choose to finalise it there themselves,
yes,
or they have the option to sue. Why is it a benefit to them?
Well, it may be a benefit to some victims to feel that they have finalised that aspect of their claim. I heard and listened with great interest to what Mr Hirschbach said about that he went through a process and for a period of time found the signing of a release to be part of his healing process, I think he said. And I also heard what he said subsequently. So, as I said, Your Honour, I can see arguments both ways.
Well, where's the other argument in favour of imposing that obligation on the victim?
I think Your Honour, my answer is that to the extent that finality is a benefit, then that benefit is present. Beyond that, clearly someone who has a legal claim and gives it away is giving something away.
Yes. Yeah. In return for a sum which the church would give them anyway.
Well, when the scheme was set up, the church's position was that they would not otherwise.
I know, but once the scheme's set up, the church is saying anyone who comes to us can justify to the independent commissioner an entitlement to a modest sum will get it.
Yes.
But they have to forgo any common law right.
Yes.
Can you understand why that might be seen as a scheme that protects the church?
Yes, I can understand that.
Unfairly. Do you understand that people would see that as an unfair scheme?
I don't agree, but I can see that people say that.
Yes, Mr. Stewart.
Thank you, Your Honour. Because you'll appreciate, Mr Leader, that it leaves as a possible inference that the scheme was aimed at purchasing for the church freedom from legal process at a low price.
I understand that, and as I've said several times already, the church's view and my view is that the claims being settled through this process were claims that had no significant prospect of success, and therefore in that sense that what victims give up when they sign the release is a legal claim that's unlikely to succeed. Now that might be seen as nevertheless having some value. I can see that. I absolutely understand that.
Well, the other point is that if it has no value or corresponding disadvantage or debt to the church, then what's the point in requiring it?
Yes. Well, in a legal sense, perhaps there isn't a point. I think the other thing that to my mind is important is that the church's position until now has been that this ex gratia payment does bring that aspect of assistance to an end, and as a lawyer it is my view that if that is the church's position, there's a benefit in being clear about that. I think it would be undesirable for a victim to accept the ex gratia payment believing that that was the first in a series of payments if that's not the church's position. And until now it's not the church's position. So to my mind I think the clarity is appropriate.
Well, the easy way to do that is, as I said to you earlier, to provide that if you do sue, it's set off.
Yes, I agree. That's another...
That's as clear as a bell.
Yes, I understand that, and I agree.
And are you aware, Mr Leader, that that's in effect, according to the evidence of Archbishop Pell in relation to the Towards Healing scheme in the Archdiocese of Sydney, that's in effect what the position became. In the last 3 or 4 years, no releases were required, and there would just be accrediting if a claim was ultimately successful in court.
I'm vague. I'm aware of that in general terms, yes.
You referred to the evidence of Mr Hirschbach, and you would have heard him say how signing the release was giving power to the church, giving up power to the church, which was, in a sense, putting him back in the position of being abused, which was the exercise of what he saw as the power of the church.
I did hear that, yes.
And that's been heard from other victims too. Just reverting to the question of confidentiality, can we look at paragraph 7, at least tab 17? You'll see this is a letter in November 1996, or a memorandum rather, from you to Alex Chernov QC, who was then the chair of the compensation panel, is that right?
That's right.
And Mr. Ted Excel, the business manager of the Archdiocese, copied to the independent commissioner, and it's dealing with the question of the basis for compensation. And we scroll down further. You'll see that section beginning, having reread paragraphs F and G, I suggest that at the outset of the process there should be a package of documents provided to the applicant that include, and now before we carry on, ultimately the way it worked, there was a package of documents provided to an applicant after there'd been a finding of abuse by the independent commissioner, is that right?
So well, the application for compensation form, is that what
Yes.
you're referring to? So that includes with it the various consents and so
Yes.
on. So I'd agree that's a package that.
And then
I think that document is generally available, but it's a precondition to seeking compensation that you have a finding from the independent commissioner. So ordinarily it's the independent commissioner who would provide that form to the victim.
And the one release is to enable the independent commissioner to report to the panel.
Yes.
Another one is to enable CareLink to report to the panel.
That's right.
Yeah. And you'll see the last dot point on the page. You say also, as a question almost, presumably an authority to disclose the same information to Coors. Now, do I understand it correctly that that wasn't followed through?
That's right. This memorandum's referring to a memorandum from Mr. Chernov to me setting out his thoughts, and at that time the thought was that the compensation, I think it was Mr. Chernov's proposal, that the compensation panel would have a person as registrar or counsel assisting. And ultimately that didn't proceed. So I think that we were still working through how the process would work and who the participants in it would be.
Now, going back to tab 13, paragraph 4.3, you will see that it provides that the establishment of the panel and the payment or offer to pay compensation is not an admission of legal liability. The Archbishop, the Archdiocese and the Church do not accept that they have any legal obligation to make payments to complainants. Of course, the truth is that would depend on the circumstances. There may be, even on that view of the law, rare cases where the Archbishop and so on would accept a legal liability.
Yes.
And the Archbishop also recognises, reading on, that there is strong opposition from some quarters to the making of any compensation payments. Now, this is the same view we considered earlier, the one that you said not much or any credence was given to. Is that right?
Yes, it is, and I think it reflects how old this document is.
It seems to be offered here as a justification for the compromise that was adopted in the scheme.
In part, yes.
Well, it can't be consistent to not give any credence to that view, but at the same time for it to be a justification for the compromise.
Well, I think the last sentence seeks to draw all of that together and say that there are arguments going in different directions and that the process strives to achieve what it strives to achieve.
But from that, are we to understand that one of the arguments that was weighed in the balance with others was the opposition to making any payments?
Yes.
But I understood your evidence before lunch, and I may be wrong to have been that argument wasn't given any credence.
Well, perhaps rather than strong opposition, well, yes, I hear what you say. My memory is that while there was opposition, that Archbishop Pell didn't think much of it. I don't really. I mean, I see that that's still in there as part of the document, and I really can't any more than my memory is that Archbishop Pell did not give much oxygen to that view.
I want to address this question of the basis upon which it was thought that the Archbishop, the Archdiocese and the Church has no legal obligation. And perhaps that's captured in your own writing most conveniently at tab 33. That's not what I have, it's tab 33. So you'll see this is now nearly 5 years later.
Yes.
This is a memorandum from you to Ms. Susan Crennan, QC, as she then was, on her appointment as chair of the compensation panel. Is that right?
Yes.
And you set out various matters for her by way of background and so on. And on page 3 of that letter, halfway down, it says, it may be that in the course of your contact with victims, you will be asked questions about some of the legal issues arising from claims against the Church, fundamental to the initiatives that have been in place since 1996 are the following propositions, and then you set them out. Firstly, that the Catholic Church is not a legal entity, and accordingly it cannot be sued and served with legal proceedings. Secondly, similarly, the Archdiocese of Melbourne is not a legal entity. Thirdly, the office of the Archbishop of Melbourne is not a legal person, and the Archbishop is not a corporation sole. Just pausing there, can you explain in lay terms what the effect of that is, that the Archbishop of Melbourne is not a corporation sole?
Yes, that means that if a particular person as Archbishop, so let's say Archbishop Little, had some personal liability, that liability does not transfer to his successor, in this case Archbishop Pell.
So if there was a case where the abuse by a priest could, in legal terms, be visited upon a previous archbishop once he's left office, the only opportunity would be to pursue that archbishop if he remained alive, was the state not yet devolved, but the next archbishop would not be liable for that.
Yes, that is that legal proposition.
Mr. Stewart, the document you may have been looking for is behind tab 9A, I think, in my documents. There's a letter there that explains this issue, but in the words of Mr. O'Callaghan, I think. But it's actually not a bad attempt to put into lay words. If you want to use it, I don't know.
Yes, I'm indebted to Your Honour. So that's the document which is referred to. If we can go over the page of where we were. So in other words, tab 13, that's tab 33, I beg your pardon, to the 4th page towards the end, the next page. Further down it says, enclosed for your information is a copy of my letter to Archbishop Pell of 28 October 1996 concerning legal technicalities which deals with some of these issues, and also in other information also enclosed. And that's then the letter that His Honour has referred to at tab 9A. I had taken you to your abbreviated version of it set out in the letter, but if we can go to tab 9A. So the corporation's sole aspect is explained there in that paragraph on the screen.
Yes, that's correct.
And then over the page to paragraph B, a second way of putting a claim against the church has been identified.
Yes.
Or against the Archbishop, and that's that he's responsible for the control and management of priests. And then you set out a response in relation to that. In C, that some plaintiffs have alleged that the church is a voluntary association and that the Archbishop can be sued as representing its hierarchy and members.
Yes.
And we consider this is wrong at law. Sporting clubs can be voluntary associations, but the church is not.
Yes.
Yeah. And in D, the final allegation has been put as to the effect the Archbishop is liable as the employer of priests. Once again, we take the view that this is simply wrong. The relationship between a priest and his bishop is, of course, regulated by canon law. It is not an employment situation.
Leaving aside the issue of vicarious liability, you're aware of what's been said on behalf of the Bishops' Conference now about what the church should do.
Yes.
And you're aware of what the Victorian Parliamentary Inquiry recommended be done.
I am.
That is to create a vehicle, however you do it, whereby the church can be sued.
Yes.
And people can recover against the church.
Yes, that's correct.
Now, I know you were carrying out your duty as the lawyer in advising as you did, but was there discussion amongst those who you were advising that in fact this wasn't right, that something should be done to provide a vehicle that could be sued?
There was certainly, I think, the entire context of the discussions with Archbishop Pell and others from the end of July 1996 through to the point of time of this letter in October was that in the absence of legal liability, what ought to be done. I suspect that there was probably also some discussion as to whether there were defences available that ought not be taken, and I think that's why this letter is titled Legal Technicalities in quotation marks. I think that, as I recall, there had been discussion in the media at that time about whether the church would or would not take so-called legal technicalities, and the proposition being advanced in this letter and in other discussions with the Archbishop was that these were substantive legal defences and not technicalities. So,
well, they're substantial legal defences, but it's fairly clear from what the Church, through its bishops, is now saying, and the Victorian Parliamentary Inquiry is saying, that it's not the right way to go.
Yes, I agree.
Well, was there a discussion back then which suggested this wasn't the right way to go?
Well, as best as I recall, the discussion was that the law is the law and these are the defences, so what ought to be done? And the answer was to establish the Melbourne response.
So no one reached the view that it was the wrong thing to do to take these defences and not provide a capacity to sue. Is that?
That's correct. No one reached the view that it was the wrong thing to do. If that view had been reached, then no doubt an alternate course of action would have been taken by the Archbishop.
Has it come as a surprise to you that the Church's position, through the bishops at least, has now changed?
No.
Why not? No? Why hasn't that surprised?
Because I think 20 years, almost 20 years down the track, everyone's understanding has increased a lot. There was some discussion yesterday with Mr O'Callaghan as to why his appointment was only for a period of 6 months. And my recollection is that that was reflective of the the significance of the problem as it was understood and the issues as it was understood to be at that time, which clearly was a completely inadequate understanding.
Well, what understanding has been achieved that's caused you to see that it's proper or appropriate for the church to change its position and provide a vehicle to be sued? What have you come to learn that's caused you to see that as the appropriate position?
I think Your Honour's asking me to summarise the last 18 years of my experience, which I would struggle to do. I don't know how to answer that in a simple way.
I can understand you saying there's more victims have come forward.
I think
and the problem is larger than people may have realised at the time. But why does that cause a change in it's proper to change the church's capacity to be sued?
Your Honour, relevant factors would include not only the number of victims, but a much greater understanding of the long-term effects of abuse. I think an increased understanding of the failures of the church to deal properly with complaints earlier, an increased understanding that there were complaints made that were not properly acted on. I think all of these matters, and no doubt others, all contribute to the increased level of responsibility that the church now proposes to take.
Was it not perhaps, Mr. Leader, that the political environment is completely different, that victims and their perspective are far more, I withdraw that victims are far more outspoken, that victims' perspective is given far more airing, there's a royal commission and so on, that's the context in which the change now comes, rather than that there's any greater understanding of child sexual abuse in the church? I think it's both. I was hesitating to answer Your Honour's question because I knew I would do so inadequately, and I absolutely agree that the factors to which you've referred are extremely relevant as well. I mean, perhaps put briefly, the people won't stand for it anymore. Well, that may be so, yes. And I can understand that. Can you think of any other organisation, institutional organisation, that enjoys that sort of privileged position where employees are not employees, where there's no continuation of legal title over time and so on? There's certainly other religious institutions that would fall within the same category. I'm now trying to think back as to what the law around unincorporated and voluntary associations was 20 years ago. That's changed as well. I think one of the factors is that the church as an institution existed before the Australian legal system came into being, and these things have unfolded as they have unfolded, and to the extent that the time for change and reform has come, I'm absolutely supportive of that. Would you agree that the position that the church enjoys in the law, as articulated by you in these documents we've looked at, is a peculiarly privileged one? I don't know that I agree with your words. I agree that it's different, for instance, from a corporation. Well, you would agree, I understand from what you've said, that it's become an anachronistic one. Yes, I think so. Perhaps we can go to tab 33, which was your letter to Ms. Susan Crennan, QC, and on that same page, but if we can scroll up to the first paragraph. can read the first couple of lines to yourself. And in about the 6th line, it says, although the Archdiocese and the wider Church have come under some criticism for relying on so-called legal technicalities, the position of the Archdiocese is that if an alleged victim elects to bring legal proceedings, then having chosen to play in the legal arena, the plaintiff must play to the legal rules and expect to be faced with all of the defences and legal obstacles that are available to the defendants. That really encapsulates what you were trying to explain earlier about the approach that was taken at that time. Is that right?
Yes, yes.
We can go back to tab 13, to paragraph 4.6, where we were earlier, I think. Perhaps over the page from where we were. 4.5, you will see, deals with, sets the cap as it then was at $50,000, and then 4.6 sets out how claimants remain free to use the normal court processes if they wish. If they do not wish to avail themselves of compensation. In that event, they should expect that the proceedings will continue to be strenuously defended. I'm just interested to understand whether you understand there to be a difference between saying a case will be defended and saying it will be strenuously defended.
I think there is a difference, yes.
There is a difference?
Yes, I think so, yes.
And what would that difference be?
I think to say that a case is strenuously defended reflects that every point that is open to a defendant to take would be taken. I think that's what that means.
It'll be fought out in the tough way that litigation is sometimes fought out between commercial opponents. Is that right?
I think that's what that language means. Right?
That's going to frighten the average person, isn't it?
Yes.
Was it intended to do that?
I can hear the response before I give my answer, but nevertheless, my answer to that is that no, it was not, and that it was a reference at the time to, and I think I make some reference to this in my statement, a reference at the time to a particular law firm that was acting in a way that I perceived and that others perceived to not be in the interests of their clients. And I might say that my opinion is that that view was ultimately vindicated by the disciplinary proceedings taken against that lawyer for overcharging his clients in other matters. And I do want to make it clear that in making this reference, I in no way refer to any plaintiff lawyer or any lawyer acting for a victim in relation to matters in recent years. I make no criticism of them at all.
So this was put in to aim at one lawyer?
Well, yes, he had a large number of clients at that time. That's my best recollection of why that language was used at that time.
It continued to be used for quite some time after that.
It continued to be used, Your Honour, until the Fosters made a complaint about it. And I think their complaint was well made, and I think the language was inappropriate.
The point, of course, to this part of the four-point plan is to discourage civil suits.
I understand why you say that. I think that at the time the perspective was, as that paragraph says, that complainants are free to use normal court processes, but if they are, the case will be defended. But there is now an alternative which was not there before. So why I don't really agree with your suggestion that it was intended to discourage plaintiffs was that I think what it was seeking to say was, if you are suing, then there will be no change to the position that the Church has taken through the 1990s, which was a position of strenuously defending cases. But there is an alternative which you can go through, see whether you're happy with the outcome, and if you are happy with the outcome, settle your case. And if you're not happy, then in this aspect of the Melbourne response didn't change the position.
I suggest it certainly leaves the impression, the use of the phraseology strenuously defend, perhaps taken together with the sentence we looked at earlier in paragraph 4.3, which stated that the Archbishop, the Archdiocese and the Church do not accept that they have any legal obligation to make payments to complainants, was to discourage any civil suits being brought.
I don't want to be understood as seeking to defend that language as being appropriate now. I'm seeking to explain why it was used back when it was.
In your statement, paragraph 91, on page 23 of your statement, you can read the first part of that yourself, as we can to ourselves, Mr. Leader. And then you'll see in about the 8th line, it says, I was seeking to make the point that in considering whether to accept the offer or to pursue litigation, it should be understood that if litigation was pursued, it would be defended on the basis that the defence was legally very strong, and that accepting the offer being made might be considered to be a better outcome than not accepting the offer and running and losing litigation. Now, was that in the context specifically of the letter to the Fosters?
That's what I'm referring to there, yes.
Okay. But so that explanation wouldn't be one you would apply to this document, which is generic, and where a particular case might actually be very strong, others may not.
I agree that that language doesn't apply to a case that was very strong. Back in 1996, I had not yet encountered any cases that were strong, and the cases to which Mr O'Callaghan referred yesterday in relation to Father Baker were at that time not cases of which I was aware. My experience then, I think I said before lunch that I'd had experience with some 30 cases, and my view was that all of those cases were cases that were unlikely to succeed.
Right, returning to tab 13, if we can look now at, on page 7, paragraph 4.9, the panel will determine guidelines appropriate to the method in which it is to operate. That ultimately was left essentially to the compensation panel, those guidelines. That wasn't done in advance.
That's correct, yes.
And 4.10, to be eligible for an ex gratia compensation payment, the complainant will need to establish the factual basis of the claim. The panel will consult and liaise with the Commissioner in this regard.
Yes.
Now, in any claim, common law, there would be elements that would have to be established, obviously liability, causation, and then put loosely quantum being the sequelae of the acts as a consequence of the causation. Here we have the Commissioner, independent Commissioner, essentially deciding, yes, the abuse happened, a payment should be made.
Yes.
Am I right? And then the panel deciding how much within its limits to pay. Is that right? Was particular consideration given in the conceptualization of the scheme to questions of causation?
The concept was that that was irrelevant.
And that was one of the compromises in a sense?
Yes, one of the compromises, yes.
So it wouldn't be necessary to establish causation, certainly not in a legal sense.
That's so. Yes.
Now, at tab 21, as I understand it, are the compensation panel guidelines that were developed and which you then circulated to the compensation panel members. Is that right?
Yes, I think so.
And those guidelines don't deal with the difficult question that His Honour has put of how to decide whether in a particular instance, what amount should be paid between 0 and 50.
I'm not sure whether they're in that document or not. I know that Mr. Chernov did write something about that.
Do we have that? I'm not conscious that I've seen it, but we may have it.
Me neither, Your Honour.
I can certainly locate the document overnight, but I believe that it's certainly not a complex formula or anything like that. On the contrary, it was a statement of several sentences along the lines of the panel seeking to recognise the physical, mental and spiritual suffering and formulate of the victim and formulate an ex gratia payment.
We'd like to see the document, yes, because certainly, as you would have gathered, we're struggling to work out how it all pans out.
And the way in which matters worked is that the compensation file, after the panel had made its finding, would get sent to you. I withdraw that. Let's have a look at your statement at paragraph 58.
Can I say, sir, that I think the document to which I'm referring may be one of the documents referred to at paragraph 43 of my statement.
Let's take a look at that, 43.
But I may be mistaken, but I think that's where I refer to that.
And by that, are you referring to the two that are in the bundle? In other words, the first two tabs, 20 and 21, or are you referring to the others that are not in the bundle?
I can't tell from looking at this which the documents referred to, other ones behind the tabs and which are not.
All right, well, let's go to tab 20. Tab 20. And at the foot of that page, perhaps, is this what you were thinking of in general terms? So this is a memorandum to members of the compensation panel by Mr. Chernov.
Yes, that is.
In general terms, the approach the panel will take in dealing with assessments will not be one whereby it seeks to compensate the applicant for economic loss, pain and suffering, as may be done in workers' compensation or personal injuries context. Rather, the panel is to decide the appropriate recognition of the physical, mental and spiritual sufferings experienced as a result of the relevant abuse. This particular statement is not intended to oversimplify the problem of how one determines such an ex gratia compensation. Is that what you were thinking of?
Yes, it was. And in particular, Your Honour, the last sentence.
So in conventional terms, is it pain and suffering?
But it is pain and suffering. Is that your question?
Is that what it is?
Your Honour, I have always understood that what the panel seeks to do is to, in part, have regard to the effects of the abuse, and in part to have regard to the seriousness of the abuse, and to consciously disregard the approach that a court would take in assessing general damages of looking only at the effect and not the seriousness, and seek to, I'm probably not explaining myself very well, but to seek to give a recognition of the seriousness of the abuse and also have regard to the effects and seek to combine all of that.
So serious abuse with no effect, if you can assume such a proposition, wouldn't achieve a maximum sum.
I'd suggest that serious abuse with no effect wouldn't achieve a common law outcome,
but would it achieve?
And that the intention is that it would achieve an amount. Whether it would achieve the maximum amount, I don't suggest that the approach is that linear, but that I suppose perhaps the best analogy is I can give in legal terms is to say it's a combination of general compensatory type damages for pain and suffering with a recognition of exemplary or aggravated damages as well. So having regard to both factors, not necessarily to the same extent. That's my understanding and my recollection based on the discussions I had with Mr. Chernov and the general discussions I've had with chairs of the panel from time to time.
We go to paragraph 58 of your statement on page 15. This is what I was referring to earlier, where you say that several weeks before the panel hearing is scheduled, this is in relation to any particular claim, I take it, Mr. Curtin's secretary forwards the relevant compensation file to me, and I arrange for it to be copied and distributed to other members of the panel, and for Mr. Curtin's file to be returned to him. In a typical case, it is only at this point that I become aware of the victim's complaint, the Commissioner's finding, and the application for compensation. Now, I would take it that that compensation file that is being referred to would include, in the usual course, at least the following: the Independent Commissioner's report.
Yes.
And any report that there may be from CareLink to the compensation panel.
Yes.
And any associated medical and psychological reports and assessments.
Yes.
And so those would come to you.
Yes.
And I take it not in a way that you wouldn't see them. In other words, they'd come to you and you would have access to them.
I have access to them. I generally don't. I'd have to say I generally don't look at them.
But if there was cause for you to do so, you would, and you'd be able to?
I would be able to, yes.
And to some degree this may go back to matters we covered earlier, and if you find yourself repeating what you've said before, I take responsibility for that. Can you explain how you understand it that process whereby you receive all of that information and those reports does not breach the independent commissioners and the compensation panel's undertakings of confidentiality to the victim?
I don't believe that it breaches the independent commissioner's undertaking because the commissioner's finding and report is, as I sought to explain earlier, is intended in part for the Archbishop, and I believe that in my capacity as solicitor for the Archbishop, I'm within that that disclosure.
Right, I understand that. And then in relation to any reports from CareLink itself or independent medical, psychological reports and assessments?
Yes. Well, I consider that those documents are disclosed to me on both a confidential and a without prejudice basis.
Well, the standard confidentiality release for CareLink has the applicant for compensation releasing CareLink from its obligation of confidentiality in order to be able to have what's in the hands of CareLink forwarded to the compensation panel. But it doesn't, as I understand it, include being able to forward that material to the archdiocese, archbishop, or their lawyers.
Well, it's not forwarded to the Archbishop. It's forwarded, I understand the point that you're asking me about, and it's forwarded to me in my capacity, I believe, as the instructing solicitor for the chair of the panel. And I do absolutely recognise the confidentiality of the documents, and while I concede that they are available for me to have regard to where I'm minded to, what I say to you, Your Honour, is that I don't.
This is the Chinese walls inside your head issue, isn't it?
No, Your Honour, it's
I mean, that's not said in any way critically, but that's the problem, isn't it?
I understand the problem, yes. Yeah.
Because the problem is, when you say you receive them as the instructing solicitor of the chair of the compensation panel, the question is, well, instructing solicitor for whom? And that must be for the Archbishop or the Archdiocese.
Yes, well, it's the Archbishop who appoints the chair and the other members of the panel.
So,
akin to the independent commissioner, their mandate is to undertake an independent assessment.
Do you think it might be better if you weren't in that loop?
Yes.
That you were confined to advising, if that's what he chose, the Archbishop, as far as the process of commissioner and determination is concerned, you were nowhere near it. You were just out there.
Your Honour, in the course of reflecting on these matters to prepare for the Royal Commission, yes, I have formed that view.
Mr. Leader, an issue that arose early in the process, and perhaps because it was raised explicitly by the Fosters, was the one of Medicare payments. Can you just explain what was the issue?
So the sorts of treatment and counselling that CareLink funds could be thought of as falling into two categories. One, psychological and other treatment, which at that time did not attract any form of Medicare rebate, although I think the position has slightly changed in some circumstances since. And two, treatment from medical practitioners, which was covered by Medicare. In relation to the latter, the issue was whether CareLink was intended to fund the full amount of the payment or only the gap between the Medicare rebate and the actual cost. That was the issue.
And a perspective was articulated that this was by CareLink seeking to have a situation where it only funded the gap. It was, in effect, the Church burdening the taxpayer with the obligation to pay as the consequence of abuse by priests.
Yes, that's the argument. Yes.
And how was the issue resolved?
The issue was resolved by, seeking, in effect, a ruling from the Health Insurance Commission as to whether it was permissible in the context of the CareLink structure to claim only the gap. And that was ultimately the advice that they provided.
we've covered briefly questions of deeds of release, but I'd like to take you to a particular, which I understand to be the sort of current version at tab 61. Perhaps we can scroll down a bit. Would this be the current version of the deed of release? Are you aware?
I need to see a little more of it.
You'll
Yes,
see.
looking there at recital F, that suggests to me that is the current version.
Yes.
Without having checked the rest of the document, I think that's the current version.
Yes, that's what I wanted to ask you about. So it records there that on the 4th of April 2014, the Archbishop, that's Archbishop Hart, I take it,
Yes.
announced the establishment of a consultation process to consider whether the current cap under the Melbourne response should be increased or removed, and said that any changes arising from that consultation process would be retrospective to the announcement date. The Royal Commission is also examining redress schemes, and then in brackets is the definition of possible reforms, and then in G it's recorded nothing in this document prevents the applicant from seeking further redress in relation to the abuse or any rights the applicant may have as a result of changes arising from the possible reforms. Can you explain how these changes to the release arose and what their effect is?
Yes.
Or intended to be?
Well, the changes arose because of the developments, the matters referred to in paragraph F, and in particular the announcement of the Archbishop, and discussions between me and the Archdiocese that in circumstances where the Archbishop has said there's going to be a review process and that might lead to a change, and that change would be retrospective, it was appropriate to document that and to make it clear that a victim who wishes to accept compensation in the meantime based on the current cap of 75,000 should have clarity that if as a result of the change, so if the cap increases or if the cap is removed or if as a result of the consultation process there is some other change, that they would be no worse off as a result of having accepted the offer. So that's what is intended by this.
So in part it would be to try and ensure that the whole process wasn't just brought to a halt pending the resolution with regard to what you refer to as possible reforms.
Absolutely.
And in the
And
period,
indeed, and in addition, to put beyond doubt, if the outcome of this Royal Commission is some change that impacts on existing deeds, then while it might not be necessary to state that, to make it express in the document that if there are changes to past settlements as a result of this Royal Commission, that this deed would not in any way seek to stand in the way of those changes.
and to your knowledge, in the period since April of this year, have there been acceptances of offers of compensation and deeds of release in this form signed?
Yes.
Do you know how many?
I don't. I would guess in the order of a dozen.
Did the Archbishop or the Archdiocese in the process of the Melbourne response ever require confidentiality or silence with respect to the abuse itself,
No.
or to the fact of a settlement having been reached?
In settlements through the Melbourne response, no.
By qualifying your answer in that way, you suggest that in some other settlements there have been such requirements of confidentiality.
Not as to the fact of the abuse, to my knowledge, but as to the settlement, yes. And I think Mr. and Mrs. Foster would be aware that the settlements with their family are an example of that.
So within the Melbourne response, is it the case that the only confidentiality that was required was what one might term without prejudice confidentiality?
Yes.
In other words, if an offer of an ex gratia payment was not accepted, the fact of the offer having been made would be kept confidential in any future legal proceedings.
Yes.
So those answers you've given me about no confidentiality with respect to the abuse being required, that's in the context of a deed of release, is that right?
Yes.
Can we have a look at tab 271 at page 3? You'll see that this is Mr. AFA's application for compensation form, and that at the foot of the page we can see it's dated as recently as 28 February 2011, and it has various undertakings and releases in relation to confidentiality, but particularly if we can look at paragraph D, and you may need to see above that if we can see the opening part of the paragraph. So AFA says he hereby applies for ex gratia compensation in respects of sexual abuse committed and so on the following basis, and then D, neither I nor any person acting on my behalf, and then we can leave out the rest, the members of the panel, Archbishop, etc., will, save as required by law, disclose to any person, rely or seek to rely in any arbitral or judicial proceedings, whether or not such proceedings relates to the subject matter of this application, on any communication, statement or information, whether oral or documentary, made or provided in the course of or in relation to the panel's deliberation.
Yes.
So that's quite a broad undertaking that an applicant for compensation undertakes with regard to communications, statements or information in whatever form, either made or provided in the course of or in relation to the panel's deliberations.
Yes.
So that, as I'm reading it, would cover a medical report, for example, or assessment that an applicant for compensation might have procured from their own medical professional, and that was provided by the applicant in the course of or in relation to the panel's deliberations. But the applicant would be required not thereafter to be able to use it or rely on it or disclose it to any person.
I'm sorry, could you give me that question again?
Yes, it was long. As I read that, that would have the result that an applicant for compensation who provided to the panel a report of his or her own medical practitioner in support of the claim and was thereby used in the course of or in relation to the panel's deliberations would not be able to be disclosed by the applicant to any person or relied on or be sought to be relied on in any arbitral or judicial proceedings.
I now see I see what you're putting to me.
I can't imagine that was intended.
No, that's absolutely not the intent.
It may have to be
provision.
It may have to be revisited.
Yes, I agree.
Well, while we're looking at this document, can I ask you a couple of other things? Subparagraph B, the Archbishop will offer to me such amount as may be recommended to him by the panel, provided I execute appropriate releases and discontinue any relevant legal proceedings.
Well, obviously the offer precedes
Sorry?
the offer obviously precedes the signing of the release.
Well, the way that's worded, you waive your rights when you make the application.
I think the reference to offer to me is to be read as paid.
Well, maybe that needs attention too.
Yes, I
It's
agree.
also a little vague. Provided I execute appropriate releases, the person's not told what they are.
At that point, they're not. No.
Well, this is the document they're asked to sign when they're making an application.
No, I think elsewhere, though, there is an explanation that the release is a release of any legal claim with a carve-out for entitlements through CareLink.
Now, a person who approaches the panel would be entitled to procedural fairness.
Yes.
Does G seek to take that away? In the sense that you can't have it reviewed?
Sorry, can I see G, please?
Oh, sorry. I irrevocably waive any rights I may have to seek judicial review of any act or omission. Now, if you're not given procedural fairness, is G seeking to take away your capacity to have it reviewed?
I can see that argument, Your Honour. It's never been...
Well, hopefully it's never
been
arisen.
pushed. It's never arisen, no.
But maybe you need to look at that too.
Certainly, Your Honour.
Yes, Mr. Stewart, do you have anything more today?
Nothing that can't wait until tomorrow, Your Honour.
All right, I think we might adjourn there and resume tomorrow morning. Now, tomorrow we will adjourn at 3:30 or thereabouts so that arrangements can be made to connect to Rome and so on. And then depending upon where we get to, we might take a short break in proceedings at about 5:30 to allow everyone a little bit of respite before we finish the evidence of cardinal health. But we'll play that a little bit by ear, but that's the general intention for tomorrow. We'll adjourn until 10.